Okay, good evening everyone. Welcome to lecture 7, the penultimate lecture this term. Last week we discussed the philosophy of animal rights, and I ended by saying that even though philosophical debates are very relevant for animal rights law, a moral right for an animal is not the same as a legal right for an animal. So today we want to move into the legal theory of animal rights. And in fact, I think it's such an important topic that we devote 2 lectures to it. So we're going to start with the first part today, and then the last week of term, next week, we're going to tackle the second part. And this goes also to what we were just discussing before. Because there's so few cases in animal rights law, there's a lot of open theoretical, conceptual questions. And so the legal theory is really quite important. And I think even though some of what we're going to be seeing today and next week may seem abstract at first, you will see in the next term how all of these questions are actually also being asked by the courts. And they're currently grappling with these theoretical questions. So that's why we need to do so too. Okay, here's an outline of what we will be doing in this session today. The first question that we're going to look at is whether animals are fit to have legal rights, or in other words, whether they can have legal rights, or maybe they're just a type of being that cannot have legal rights. And we will be considering the 2 main approaches that people take to answering that question, the so-called choice-based rights approach and the interest-based rights approach. We will then move to consider whether animals might already have certain rights at the moment. And to make sense of this question, we will be looking at 2 different ways of conceptualizing what a legal right is. The first one is what we call the thin conception of rights, which says that animals already have certain legal rights. And the other one is a thick conception on which animals do not yet have legal rights, perhaps with the very limited exception of Cecilia, the chimpanzee, who already was granted habeas corpus. But that's jumping the gun. We will talk about Cecilia's case next term. Then lastly, another very important theoretical question is whether an animal would actually have to be a legal person to be the holder of certain rights. In other words, do animals need to leave behind, if you like, their property status and become legal persons? Something that, in fact, Francione and many others argue, as we saw in the past few weeks. But that in itself is a debated question. There are some who believe that's not necessary. Today, we will be focusing on the first 2 of these questions. And then next week, we will be considering in more detail the third question about legal personhood and property. Okay, let's start with our first question, which is the seemingly simple one, whether animals can have legal rights. There are some who believe that they cannot have legal rights. Talking about the legal rights of animals is nonsensical, right? So we need to ask ourselves whether that claim, that challenge is a correct one, a warranted one, or whether indeed animals can have legal rights. And to answer that question, it is useful to ask another question, namely, well, what exactly is the function of rights? Depending on what we think the function of rights is, we will come to a different conclusion, perhaps, as to whether they can serve to protect animals. As I alluded to before, there are roughly 2 main approaches to what the function of rights is. The first approach is the so-called choice or will-based theory or approach. According to choice theorists, rights serve a specific purpose, and that is to express and protect at the same time the choices that autonomous beings can make. Right? So on the choice-based account, rights are all about protecting particularly human beings as autonomous agents who can choose how they want to structure their own lives, what maybe profession they want to pursue, how they want to make their money, how they want to deal with friends. All of these things involve choices that we make, and they involve choices about how we exercise our rights. And so the choice-based approach says it's all about this autonomy of individuals to express and protect their choices. Then there's a radically different approach, if you like, and that's the interest-based approach. And it says, forget this stuff about autonomy. Autonomy isn't required for you to have a legal right. That's not the purpose of rights. The purpose of rights, or the function of rights, is to protect, quite simply, the interests of their holders. Right? Hence it is called the interest-based approach. Let's look at an example. Consider the choice-based approach. Assume that Sophie lent a book to Kenzo. Now, on the choice-based approach, Sophie's right in her book and the fact that she has a right to claim it back from Kenzo is what this right is supposed to protect, or it's all about protecting her choice. So imagine, Sophie exercising that choice. Kenzo, you've had that book for long enough. I'd like to have this book back. And as a result, she triggers this duty, if you like, this action in Kenzo to return the book to the rightful owner, Sophie. Right. According to choice-based theorists, this is something that has to happen in an autonomous way and also conscious of, for instance, the legal ramifications of what would happen if Kenzo refused to return the book. Sophie could, basically bring a lawsuit against Kenzo if she really wanted to, right? So she's taking all these conscious choices, if you like. And that's what rights are supposed to protect. But now take a sort of a slightly, different example here where we have Matilda, an animal, and say Matilda would like an apple that Kenzo has. Can Matilda really exercise a choice by, say, mooing, and then the apple is being, brought to her by Kenzo? The obvious problem that this raises is that many animals might not be autonomous in the sense required by the choice theory, right? Now, you might say, well, animals are autonomous in certain ways, right? Perhaps. Matilda has her own agency that she expresses. Maybe she has, a calf, depending on perhaps the farm that she lives on. And she may be able to take certain actions, exercise that autonomy, if you like. But it's not really autonomy in the legal sense, right? She would not be aware of the legal ramifications of this, even if we assume that, she was in some sense the owner of that apple, which of course raises other problems, animals not being currently able to hold property. So we have the problem of autonomy. But then an issue that this choice-based approach faces is that even if we accept that most animals might not be autonomous creatures in the sense required to hold rights, some human beings might not either. And in fact, some choice theorists are explicit about this, and they bite the bullet, if you like. They accept the consequence that some human beings might not qualify for legal rights under the choice-based approach because they lack autonomy. So take H.L.A. Hart, a famous choice theorist. He argued that these considerations about the choice theory and autonomy should incline us not to extend to animals, so that's the point we saw here first, and babies, whom it is wrong to ill-treat the notion of a right to proper treatment. Right? So what is Hart saying here? Hart says, from a moral point of view, it is of course wrong to ill-treat a baby, just as it is wrong to impose suffering on an animal, right? So we may very well have duties not to ill-treat animals and babies, moral duties. But because they're not autonomous creatures, they cannot exercise choice, and therefore, to talk of a baby or an animal as having a right to proper treatment is simply nonsensical. It doesn't work because they lack that autonomy that is required to exercise the rights in the first place. Now, some will theorists or choice theorists have proposed potential solutions to this issue that the choice-based account seems to have a hard time explaining why babies, or you could say also humans with mental disabilities, maybe senile persons, do not really have legal rights under this account. And they've tried to sort of circumvent that problem by saying that, well, they all have guardians. These beings have, say, if it's a baby, has a parent who could exercise this choice for them, right? So you can bring the choice back in through that. Or you could say, well, maybe it's even the parents or the guardians of these humans who hold the rights on behalf of the non-autonomous beings, the babies, perhaps the senile persons. So they've tried to sort of accommodate this problem of non-autonomous humans by doing that. The question for us is whether this is a really compelling answer to the problem. Because it does seem, for instance, in the case of children, to fly in the face of how, for instance, human rights practice, human rights theory, thinks about the rights of children. I just took two articles from the Convention on the Rights of the Child. The first one saying, for instance, the child shall have the right from birth to a name, the right to acquire a nationality, and as far as possible, the right to know and be cared for by his or her parents. And then Article 14 goes on to talk about, say, the right to freedom of thought, conscience, and religion. Now, it seems here that at least this convention conceives of the rights as being held by the children, and also from birth in the case of Article 7, for instance. It doesn't mention here anything about, the parents, say, holding the right on behalf of the animal. So I guess what we can say is the choice-based approach does still struggle to accommodate rights for non-autonomous beings. Now consider the alternative, the interest-based approach. And again, we've got a little graph here. So Kenzo, you might say, has an interest, very simply, in not being stabbed, harmed by Sophie. And on the interest approach, prima facie, we're going to go into more details, that will be sufficient for Kenzo to have a right not to be harmed by Sophie in this case. But consider this situation here. Assume now that Kenzo is actually the owner of this book. It's a really nice copy of, I don't know, your favorite book. But imagine Sophie would really love to have that book. She's a really strong interest in having the book. Does this mean on the interest-based theory that she has a right in that book because she's got such a strong interest in having the book that Kenzo owns? To make sense of this, it is important to look, or useful to look at what is probably the most prominent conception of the interest account, and that's the conception that Joseph Raz, famous legal theorist, has defended. Raz tells us that there are three conditions for someone or something, X, to have a right in something, phi. You can replace this with any right, basically, right to life, right to liberty, what have you. The first condition is that X needs to be the kind of being that can have rights. Kind of being that can have rights. That's the sort of first condition. The second condition is that the right, whatever it might be, life, liberty, religion, is based on X's interest. Right? So it must be grounded in the interest of X and not anyone else. And then finally, X's interest has to be a sufficient reason to hold others, A, B, C, under a corresponding duty to provide or respect phi. Right? So X has to have an interest in whatever would ground the right, or whatever the right would be, to be more specific. And that interest must be sufficiently weighty to impose a duty on others to ensure that that right is protected and respected. So if we go back to our example we considered before, again, Sophie's got a really strong interest in reading the book, or in even owning the book, claiming it from Kenzo. It will make her very happy, but of course, Kenzo himself has a strong interest as the owner of the book to keep the book, right? So if we apply this third condition that we saw before, we reach the conclusion that although Sophie might have an interest, that doesn't just give her the right to the book. In other words, just because we have interests in all different sorts of things doesn't mean we have rights in these things. The interests have to be sufficiently weighty and a sufficient reason, indeed, to impose duties on others to respect that right. And in this case, we would probably all agree, Kenzo does not have a duty to give the book to Sophie. Hence, she would not have a right under Raz's conception. But also consider another element that I sort of skipped over before, but that's actually really important for our discussion. And that's this condition that for someone to have an interest-based right, they have to be the kind of being that can have rights in the first place. Raz himself argued that animals do not actually qualify for this. He argued that animals are not the kinds of beings that can have legal rights. And his reason for this was that although he argued that animals have, perhaps they matter morally, they have even intrinsic value, he argues. He says they do, despite all of this, not have non-derivative value. The discussion is a bit sort of muddled, I think, in Raz's book. But he's essentially saying here that animals, at the end of the day, only matter because humans value them, right? Their value is derivative of how humans value them. Whereas human beings, they don't have derivative value, they have non-derivative value, i.e. they don't matter because someone else values them. They matter in themselves. Now, this is a rather unorthodox view. I think it's fair to say that most people agree that animals have intrinsic value because they are sentient, or all animals that are sentient have intrinsic value, and Raz's exclusion of them, they don't really buy, basically. They say, yes, animals are the kinds of things that can have rights in virtue of being sentient. I think that's quite widely accepted. But that raises another question for us. So, okay, we can say that animals are sentient beings with intrinsic value. What about potentially other objects that might also have interests? So, what about plants, for instance? What about potentially even inanimate objects, such as mountains, houses, tables? It may seem like an abstract consideration, but you'll probably have come across examples like this one in the news where countries around the world, including New Zealand, have granted legal rights to certain inanimate entities, such as mountains, as in this case, Mount Taranaki in New Zealand, which was apparently granted legal personality. Other examples, for instance, include India, which also seems to have given some legal rights to the rivers Ganges and Yamuna. Now, if these entities are given rights, does that mean that they have interests in this sense required by the interest theory? Now, there's there's some debate on that. Some environmental ethicists argue that, yes, plants and ecosystems can have intrinsic value and interests, and therefore they are the kind of beings that can have rights under Rass's theory. Other people, we saw Francione in the past few weeks, but also Cochrane, who's on the reading list, I think, for today, they argue, no, you need to be sentient to have intrinsic value and interests, right? So they would argue that, for instance, yes, a plant can, in a broad sense, be said to perhaps flourish if it is watered or if it has enough access to sunlight. But that's not the same as a sentient being, because a bike might also benefit from being well oiled. That's the sort of argument they make. But that doesn't mean that the bike has an intrinsic value and interests. So they would draw the line, Cochrane, Francione and others, at sentience. They would say plants don't have interests that qualify them for having legal rights. Matt Kramer, legal philosopher here at the faculty, takes an interesting view. He basically says, well, it's conceptually possible for inanimate objects, for instance, valuable paintings, to have legal rights, to have interests, in principle. However, he qualifies this by saying that from an ethical point of view, it is better to restrict rights holding to sentient creatures. So ultimately he arrives at the same stage as Cochrane and Francione and others, but he says conceptually, at least on the interest theory, it would be possible. Okay, this is just a broad sort of sketch of the two different approaches. I think what we can sort of take away from this is that there is really broad, I think, consensus, perhaps if you take with the exception of Raz, that on the interest-based approach, animals qualify as potential legal rights holders. They are fit to have legal rights under the interest-based approach. If you want, you can make perhaps an argument also on the choice-based approach along the lines of the guardians could exercise the choices for the animals and therefore the choice-based approach is not completely unsuitable. But you will have a harder time making that argument. So you will see a lot of people in the animal rights sort of debates adopting interest-based approaches for that reason. Okay, assuming then that there are plausible theories that tell us that animals can have legal rights. This takes us to another question, which is quite important in the field, which is, well, if they can have rights, maybe they already have some rights. Maybe they already hold certain legal rights. And as you will see, there's broadly two perspectives on this. On the one hand, you will find this kind of perspective. Chimpanzee, to get legal rights, this will be a first, this will be a revolution, i.e. animals don't currently have rights. They're yet to be granted legal rights. And that, I think, is usually how we present things in this course. So this, I hope, will be a familiar view to you. Animals don't have rights yet, but there's some, ongoing cases that try to get rights for animals. But then you will also come across things like this. Dogs' feelings are now recognized by law as animals are given more legal rights. Basically the view that animals are already protected in, say, the Animal Welfare Act in the UK, in other legislation, and as this legislation is being reformed, animals are given more legal rights. But the implication is they already have some legal rights. And when legislation is improved, then they're just given more legal rights. So these are two contrasting perspectives. On the first perspective, animals do not have rights yet. On the second one, they have them. So which one's right? The best way to make sense of this is to understand that these two statements, these two perspectives, operate with a different concept or definition, if you like, of what a legal right is. Let's start with the first one, the one that we can basically find in the second scenario here, the second perspective. And that's what we can call the thin conception of rights. Basically, this conception says that wherever you have an animal protection norm of some type, a legal norm, then animals will have certain legal rights. So I think we saw in our sort of statistics that it's 2/3 of all the countries that have some form of animal protection law. So in this view, 2/3 of the countries would already grant certain legal rights to animals. And that's a view held also by some scholars, not just in sort of in the media. Take Cass Sunstein, a famous Harvard scholar. He says, if we understand rights to be legal protection against harm, for instance, protection against unnecessary suffering, then many animals already do have rights, and the idea of animal rights is not at all controversial. He goes on to say, if we take rights to mean a moral claim to such protection, there's also generally agreement that animals have rights of certain kinds. So he refers here to the philosophical debates that we looked at last week. Yes, there's broad agreement that animals have sort of moral rights and that they need some protection. So yes, we already accept that. There's general agreement on that. And there's lots of legislation protecting them against harm. So animals already have legal rights. There's nothing problematic about saying that, argues Sunstein. The best way to make sense of sort of why Sunstein can arrive at this conclusion, I believe, is by applying Wesley Hofeld's analysis of rights. So maybe some of you have come across this. I know, Flora, you're taking the legal and political philosophy course with Matt Kramer, and I know that he is very keen about this Hofeldian analysis of rights. So Hofeld, for those of you who don't know him, was an American legal scholar at the beginning of the 20th century, and he wrote two very important articles on rights, basically. They're both published in the Yale Law Journal. You see one of them here on the slide. Hofeld was bothered by the fact that he believed rights are often used in many different ways, and people tend to conflate and confuse these different ways in which the term and the concept of a right is used without understanding that they're using them in different ways. And he wanted to basically bring some order into this chaos, into this mess, by showing us what the different ways are in which we can understand a right, or in fact, what the different ways are in which the term right, the concept of right, is being used by pretty much everyone. And he came up with this table. May look a bit intimidating, and we're primarily going to focus on the first element, but just very briefly to give you the gist of what he was trying to say here. Hofeld argued that roughly there are 4 different types or ways of using right. You can mean claim right, you can mean liberty, you can mean power, and you can mean immunity. And these 4 different senses, they correlate with basically a negative in someone else, usually. So take an example. If I have claim right that, say, Sean returned the £5 that I lent him, then that means nothing else, according to Hofeld, than to say that Sean has a duty to return the £5 that he borrowed from me, right? So I have the claim right, and there's a correlative in the duty that Sean holds. Hofeld argued that we can distinguish that from a liberty, even though claim right and liberty often come together. Liberty, sometimes called privilege, is basically the fact that you are free to do something. So for instance, I have the liberty to leave this room now if I want to. Hofeld would have said that although that liberty often comes with a right to be able to leave the room, it doesn't have to. In principle, I can have the liberty to leave this room without also having the right to do so. So perhaps you have a duty from stopping me that is not incompatible with saying that I have the liberty to leave on his account. This may look a bit confusing because often, as I said, the liberty and the claim right come together. But just so you're aware, he sort of entangles the two. And then we have power and immunity. These refer or relate to the claim right, the liberty, the duty, and the no right, which are just the opposites of the two rights we discussed before. So for instance, if I have a power, say, take the example of an employer, for instance, in a supermarket. If the employer can, say, impose a duty on an employee to, say, fill the shelves, then that means nothing else than that the employee has a liability to having a duty imposed on them to fill the shelves, right? And immunity and disability, this refers to something very similar, again, having or not having your legal positions, claim rights, liberties, duties, no rights, changed. So if, for example, you as the employee have a clause in your contract that says no one can force you to fill the shelves, then you have an immunity from having a duty imposed on you to fill the shelves, right? And correspondingly, your employer would have a disability from imposing that duty on you, i.e. they cannot do that. Now this is the sort of table or the framework as a whole, and although all these concepts are sometimes employed in the animal rights context, the most important one is the claim right duty relationship. So let's focus on that and don't worry too much about the other ones. Okay, let's consider this again in a concrete example where Kenzo has a book that is actually Sophie's property. She lent it to him. And now she'd like to have that book back. Very simply, we have a claim right in Sophie and a duty in Kenzo, right? Because he had the duty to return the book, that's nothing else than to say that she has a claim right in it for Hofeld. So it's always a sort of the mirror image, claim right, duty. Now, as you can probably anticipate, on this account, if we, switch Sophie with Matilda, or swap the two, and if you take something like Animal Welfare Act and the duty on humans not to impose unnecessary suffering on animals, ta-da, magically, you have a claim right in the animal, right? Because the claim right is just the correlative, if you like, of the duty. So wherever humans have duties toward animals, i.e. in all animal protection legislation, animals have certain claim rights that follow from it, according to Hofeld. Now, assuming this is reasonably clear, we can maybe have a look at the issues that this account, this thin conception faces. So one of the problems is that these thin animal rights, at least as they are right now, they don't protect basic interests of animals such as life, liberty, or integrity. Or to the extent that they do, they only do it in really sort of constrained and specific ways. So you might say animals don't have a right to life, right? So they don't have that broad life, but their interest in life is protected to the extent that, yes, there are laws that don't allow the slaughter of these animals if that slaughter is without prior stunning, right? Because if you do stun the animal, then you can slaughter it. And this prior stunning requirement does not even apply, say, for religious or spiritual purposes, right? So you have a very narrow protection of your interest in life in that you can only not be slaughtered if there's no prior stunning, or even where there's prior stunning, there isn't a religious reason for doing so, right? So very narrow, very shallow protection, if you like. In other words, using the term legal right or right in the context of a thin right can be confusing, and it should definitely not be equated with the fundamental rights protection that humans have. Now, this doesn't mean that this approach doesn't have certain merits. One important, I think, advantage that it has is that it can lower the stakes, right? So we're going to be seeing next term when we talk about the cases brought by the Non-Human Rights Project that there's a lot of rhetoric that they employ about how granting rights to animals is a revolution. It's a breaking of the legal wall that has separated animals from humans for millennia. Right? In doing so, you might say, the Non-Human Rights Project is making it harder for judges to take that step because they don't want to be the ones who breach the legal wall for the first time. Right? By taking this approach here, you basically lower the stakes. You say, animals already have certain rights, right? So these animal rights cases about, habeas corpus and other, legal personal, they're just about giving animals more rights, but they've already got some, right? So don't worry, you're not the first one to take that step. They already have some legal rights. And as such, it can then serve as a stepping stone, potentially, to extending more and stronger protection, stronger rights to animals. Okay, in the last maybe 5 or 10 minutes, consider this other conception, the thick conception, which says rights are more than just what the thin conception makes us believe. And people who adopt this view, they don't have to reject the thin conception. They can say, sure, I'm willing to accept that animal protection laws already give certain rights to animals if we apply Hofeld's framework of claim rights and duties. And if you like, if we link it with an interest-based approach, that's all fine. They hold thin rights. But don't make the mistake of, confusing that for a thick, or if you like, a fundamental right that is much closer to a human right. So Francione actually already basically made this point in his Animals, Property and the Law from 1995, where he argued, well, although the animal is wronged, it tugs at our intuitions to say that an animal has a right to have pain inflicted only when it is scientifically necessary. So he's making a similar point to what we had on the slide before. He's saying, yes, of course, you can interpret the unnecessary suffering requirement in the context of scientific experiments as granting a right to an animal not to be inflicted unnecessary pain in the context of scientific experiments. But again, that's so narrow, that's so specific that it seems even strange to call this a right. So what he's getting at here is that if we use the term right, we generally mean something more substantive than these thin rights. So the question then for us is, okay, what does it mean to have something thicker than those thin rights? There's different ways of going about this, and this is still a matter of debate, but a thick right will probably consist of a complex set, or what is sometimes called a molecule of Hofeldian positions. Right? I'm going to give an example about this on the next slide. It's going to be more than just, say, a claim right. A thick right also protects fundamental interests. Right? It doesn't just protect very narrow interests. It protects the most basic, most vital interests that an animal requires to live and flourish. It has a high threshold for limitations, right? So you might say the unnecessary suffering standard that we find in many animal welfare acts, it does require a sort of balancing exercise. Is the suffering necessary or not? But the suffering is almost always necessary, as we saw in the past few weeks, because human purposes are considered more important. If it was a thick right that animals had, then it would be much more difficult to justify a limitation. The threshold would be much higher for infringing, say, the right to life of an animal. A thick right is also directly enforceable. That is, the animal or a legal guardian would have standing to enforce the right, which is not the case for thin rights. And then the thick right would also have a dynamic character. It could progressively be interpreted by courts and be made stronger. Consider an example. I'm going to go through the same criteria again. Take the right to bodily integrity. Right. The right to bodily integrity as an abstract right, as you might find in the Constitution, consists not just of one Hofeldian, say, claim right and a corresponding duty, but of a variety of different Hofeldian elements, if you like. So it will consist of, yes, a claim right not to have the integrity violated, but also, say, a liberty to determine what you want to do with your own body. Maybe you want to get a tattoo, right? That would be protected. That's not a claim right, that's a liberty on Hofeld's framework. Or it might contain, for instance, or entail the power to consent to medical procedures. You give someone, your doctor, the right to interfere with you, if you like, right? So you change their legal position, exercising your power. The right to bodily integrity obviously also is a vital interest, or will protect a vital interest. It can only be limited in the human context, at least, if serious conflicting interests require it. Maybe someone attacks another person, in which case there can be interference with their bodily integrity, if you like. They can be shot down by the police, for instance. But this can only happen in limited circumstances, not just on sort of run-of-the-mill cases, of human ends. There's holders, guardians, if the holder cannot, who have standing to enforce the right. And finally, you can see maybe in the case law, depending on which jurisdiction you look into, how these rights generally acquire more protection over the course of time, with courts interpreting them more and more generously. Okay, so I think just to conclude on this point, we can say that the thin rights conception, I think, is a conceptually plausible one, but we should not conflate these thin rights with thicker rights. And whilst animals might well be said to have certain thin or welfare rights, as they're sometimes called, they do not currently, with very few, just a handful, if that, exceptions, have thick rights. They do not have these fundamental rights yet. And that is how we can make sense of these differing views that we saw in the media before, and that we also see in scholarship a lot. And as I said, there's lastly the consideration about legal personhood, but we'll talk about that one next week. Okay, thanks a lot. I look forward to the discussion